5 seconds to go. Start. It is also well settled that the Court of Appeal has as wide powers of appreciation of evidence in an appeal against an order of acquittal as in the case of an appeal against an order of conviction, subject to the riders that the presumption of innocence with which the accused person starts in the trial court continues even up to the appellate stage, and that the appellate court should attach due weight to the opinion of the trial court which recorded the order of acquittal. If the appellate court reviews the evidence keeping those principles in mind and comes to a contrary conclusion, the judgment cannot be said to have been vitiated. The trial court considered the testimonies of the other witnesses first before embarking upon eyewitnesses and the material witness. It gives exhaustive reasoning for its ultimate conclusion. We have already recorded the fact that most of the witnesses turned hostile. PW16, an independent witness, also states that she has not seen the occurrence and she heard that the deceased was dead before taking to the hospital. The trial court took enormous pains in considering the evidence of all the witnesses one by one. On considering the evidence of PW7, a shoe shop owner, it gives its cogent reasoning for its non acceptance. The previous bill and the relevant bill had a difference of about 8 months in between, and this witness has not seen who has purchased the chappals marked as MO8 from his shop. Similarly, PW20, who was running an STD booth, could not convince the trial court as he could not say that the accused had made calls from his booth. On motive, it was correctly analyzed that there was nothing to implicate the accused with motive to murder the deceased. PW1 was the sterling witness of the prosecution. Certainly, he had an axe to grind against the accused who had given a complaint against him. He was facing a departmental inquiry and suspension. It is too strange that he could be a chance witness. His evidence was thoroughly analyzed by the trial court, including the distance between his place of work and his residence. He did not use his wireless, which was not in operation, and went to the police station to give an oral complaint the first time, but the same was not registered. PW25 was known to him, and it is surprising as to why no attempt was made to save the deceased immediately by taking him to the nursing home, which was 50 meters away, as a normal human conduct. There are many contradictions between the statements made by PW1 and PW2. We are also surprised as to how the other chance witness Ramesh came to the place once again, a person known to the family of the deceased. Though PW1 denied the complaint against him, he made an admission that he was under suspension. There was no blood stain of the deceased on PW1 as against PW2, and the same was also not matched. We are only noting the above just by way of an illustration. The trial court went way beyond what we have recorded while disbelieving the evidence of PW1. PW2 was also seen along with PW1. He was another eyewitness. He was a duty constable. The trial court rightly doubted his presence as well. Once again, even this witness has not given any complaint. We are dealing with the deposition of a police officer who is expected to know his duty. While PW2 did not make a complaint but went on to do his duty, PW1 did not attend to his duty thereafter or informed the police station in which he was posted, though PW2 had stated that accused made an attempt to attack him by throwing one of the material objects. Even the High Court has disbelieved that the said material object was recovered from some other place, as could be seen from the recovery memo, despite the fact that it was nobody's case that the accused retrieved the same and kept it with them while being chased. Stop.